Mention. And I filed it today. We could not in some new documents that the lawsuit due to that I filed lawsuit. Mr. Ayat Soike, Learned Counsel for the petitioner, review petitioner, submits that an affidavit on behalf of the respondent number 6 was received by him today. Accordingly, he prays that he be granted a 2 weeks time to file a rejoinder thereto. Full stop. In view of the above prayer of Mr. Ayat Soike, registry to list this matter again on 22/10/2025. So, petitioner to bring on record is a rejoinder on or before they said next date of listing.
Development.
Like to mention item number 12, Lordship. Conducting senior counsel, Mr. P.J. Sweke is out of station, Lordship.
On the prayer is made on behalf of Mr. P.J. Soike, Learned Senior Counsel, for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the Learned Additional Public Prosecutor. Registry to list this matter again on 14/10/2025. On Mr. S.K. Talukdar, Learned Counsel for the petitioner, submits that the brief has been misplaced in his chamber, and accordingly, he would now be required to reconstruct the file and accordingly prays for an adjournment in the matter. Registry to list this matter again on 15/10/2025. No further adjournment would be granted in the matter. Mr. Chaudhary, you need not wait. We'll complete this because yesterday the files did not come to me. If I can do it, I'll just go through it and then pass if possible. You need not wait. We'll do the needful. Yes. We have heard Miss, what was the last order? She wanted some time for. Yes, Mr. Bhatt. The only thing, other thing that presence in the shop, a recovery at least of some notes, but the knowledge that this was forged, how do you impute that to the, because there are evidences of the witnesses, prosecution witnesses, which says that on just mere looking by the eyes, you are not able to detect whether it is forged or not. No, although the appellants herein have not disclosed as to how they came into possession of the notes, but the IO has in his deposition stated that these notes were given to them by one brother-in-law, son-in-law, absconding. How can I pass not there? None appears for the appellant on call. What do we do? Yes, madam. What happened? Huh?
Appearing from the appellant.
You have to. Huh?
You were under other court, Lordship.
Then argue.
My senior is arriving.
Hmm?
My senior is engaged in another court. She will come, Your Lordship.
We have heard her. We are dismissing it then. Only that PW 7. And that is that shopkeeper, grocery shopkeeper. So one is different, one is subsequent, but the knowledge can be imputed from 7. And this was also put to them in 313. No clarification. That is also not there.
Yeah.
Okay, we'll wait for some time. We'll wait for some time. Let madam come. Busy, so we'll have to wait. Yes. Yes, Mr. Soma.
Net bill of money.
Hmm.
The case matter where under 2 sections, total of 10 years of
Hmm.
punishment is given to the accused. Will also kindly come to the judgment first, page 29.
Hmm.
Then I'll take a lot of to the evidence also. It starts from page 8.
Hmm.
Here the allegations was that the accused Rana Das and Numali Das were in love for the last 2 years. That is admitted position by both the victim and her father also. And one night on 17/11/2009, both are having in a cohabiting position
Hmm.
the bed of Numali Das,
Hmm.
and her sister was sleeping beside her. And the father heard the sound of the cot. He was in different room. Sound of the cot. He came to the room to find out what happened. Then he found Rana Das was sleeping and having cohabitation, but in physical relationship with Numali Das. She was more than 18 years. That's the admitted case. And ultimately, he ran away. There is allegation of house break also. The bamboo door was tied with a rope. There was cut and he entered inside.
Hmm.
And for that, under section 457,
There was no evidence adduced by you.
no, I didn't reduce because there was sufficient evidence in favor of me by the prosecution. As much person is not very legible, so this could directed the registered to translate it,
Hmm.
translated version.
I've gone through it. You can refer to the PWs you want to.
PW1,
There was a love affair.
love affair. So my plea is, it is a consensual relationship. I'm referring to PW1, father. It's in English translation, there is an SMS version also. There is not very legible. I know the accused Rana Das. He is a youth hailing from our neighborhood. Numali Das is my daughter. Around 12 midnight, one day about 8 months ago, when I heard some sound coming from the bed in the room of Numali, I got up and after going to Numali's room, I saw Rana there. I tried to grab him, but in vain.
Mr. Borua, have you gone through the evidences? PW2. She says that there was IPC2 love affair, promise, physical relationship. So 376 may not be there, but what about hmm. But there was no allegation of cheating here. No charge under cheating.
No, no.
There is no.
Framed. So the ingredients that have come on record basically can be set to 1415. Hmm? Because PW2's evidence is very clear that his presence there was with her consent.
Yes.
Hmm. Hmm. The matter today. So prayer is not objected to by Mr. R.J. Barua, learned additional public prosecutor. Full stop. Accordingly, registry to list this matter again on 17/10/2025 for further hearing. So Pathada say further hearing today.
Obliged, sir. Deeply obliged.
But show me how you can discharge your honors with regard to knowledge of the
Yes, sir.
notes being forged.
Of course, Lordship.
PW7 brings on record that you were put that question in 313, nothing.
Lordship, yes. Obliged.
Mr. Barua, Mr. Goswami, both, what to do here? There's nothing for you to do. Matrimonial matter maintenance. There was a direction also to continue to pay the maintenance amount, 5,000 by this court. None appears for the parties on call. Full stop. Only thing is whether that payment is being made or not. That much only. No, not interested. Okay, we'll not disturb it before the vacations. For the ends of justice, registry to list this matter again on case 24/10/2025.
Into 10.
May it
Yes.
please your lordship.
Hmm.
Item number 7, my lord.
Hmm.
Rajendra Maharaj.
Hmm.
In the meantime, we have been informed and as well as informed the other party that he died, my lord. To that effect, a report was called for earlier of this.
The others are alive. Other petitioners, other appellants, Maheshwarnath Mahadev Pathak, Rajakanta Kolita, they are alive. Hmm? Who is appearing for item number 8?
8,
Mr. Das, you are appearing?
I'm appearing, my lord. Item number 8, my lord.
9?
9,
9 also.
8 and 9, my lord.
10? Okay.
10.
On behalf of D. Talukdar.
Okay, where is Mr. Talukdar? Today, everybody seems to be busy in the new matters. Huh?
My lord, one of our appellant, my lord, is Maheshwar Nath. Even he is expert, my lord. But that report has not
Come.
received.
Okay. 7 to 10, huh? What's up? on the earlier date of hearing, this court was apprised that the appellant in criminal appeal number 11/2013 and criminal appeal number 18 of 2013. 18. Mahadev Patak.
17 and 18, madam.
17 and 18, both.
No, only
Death is
Mahesa Nath, madam. That is 8, item number 8.
criminal appeal number 17
17
of
oblique 13.
2013 had expired during the pendency of the present appeal. So a report in the matter was called for from the respondent. So, the learned counsel for the respondent submits that the report has not been received and the matter is being inquired into by the authorities of the Central Bureau of Investigation. So, in view of the above, registry to list this matter again on 27 24 day pari 24/10/2025. The report with regard to the report as called for in the matter be placed before this court on the next date of listing.
Obliged, madam.
Master.
Deeply obliged.
Okay. Hmm. Hmm. Receive the amount. Lekha. Heard Miss B.S. Goel, a learned amicus curiae. Also heard Mr. T.L. Chaudhary. M.K. Chaudhary. Now we'll have to write junior then. M.K. and also Mr. M.K. Chaudhary, learned counsel appearing for the respondents. First off, on the last date of listing, this court had required the learned counsel for the respondent to receive instructions as to whether the respondent has received the complete check amount along with interest as directed by the learned trial court. Also, Mr. M.K. Chaudhary, learned counsel, on instructions have submitted that the check amount along with interest has been received by the respondent herein and his grievance has been redressed. Also, the said developments are taking place in the matter, the direction as the sentence as passed by the learned trial court to the extent of payment of the fine of rupees 1,40,000 has been complied with in the matter. Also, the learned trial court had, on appreciation of the evidences coming on record, also sentenced while convicting the petitioner herein under section 318, had also sentenced him to undergo simple imprisonment for 6 months. Also, the said directions were so passed in the year 2010, and the check in question was issued by the petitioner herein on 6/12/2008. So, considering the fact that considering the long lapse of time occasioning after the issuance of the check dated 6/12/2018, as well as the judgment and order dated 2/6/2010 passed by the learned trial court, this court is of the considered view that the sentence as passed in the matter requiring the sentencing, the sentencing, considered view that the sentencing of the petitioner herein by the learned trial court to undergo simple imprisonment for 6 months would require to be modified by invoking the provisions of the Probation of Offenders Act 1958. Full stop. For the reasons noted herein above, this court modifies the sentencing of the petitioner herein by the learned trial court by judgment dated 2/6/2010 to the extent of sentencing him to undergo simple imprisonment for 6 months as modified, and the petitioner herein is directed to be granted the benefit under the provisions of the Act of the Probation of Offenders Act 1958. Also, the said order, however, would not. However, the fine imposed by the learned trial court while the impugned judgment dated 2/6/2010 is not interfered with, and as noticed herein above, the same has already been deposited by the petitioner herein. Full stop. In view of the above, hey, last of paragraph to the two sureties, bond, disposed of. This court places on record its appreciation for the assistance rendered by Ms. M.S. B.S. Goyal, amicus curiae, for towards a disposal of the present petition, revision petition. Yes, Mr. Uddin. Where is Mr. Aibot Thakur? Can you get hold of Mr. Aibot Thakur? You have got hold of that rule?
Rule, my lord, on the last occasion.
You told me that there is
Yes.
a rule.
I am told that rule also, but on search I found that in fact it is an act in 2002 where every provision has been prescribed. How to take cognizance, etc. Procedure has been laid down. Section 3 and 7. Section 3 provides the basic part and 7 provides punishment 1 year. Rule I have not found. As in 41.
But 41,
No,
40 is also not.
No. I have tried my level best with all my resources, but I have not found any. This act also speaks about rule. That is also not there.
No, 40 pertains to the transportation of forest produce. Now, what I have gathered is that if the forest produce is to be sent outside Assam, Supreme Court directions are there in a decision,
Yes.
which says it can only go by your train. No other mode is prescribed. But intra the state, there has to be a mode prescribed.
Other end, my submission is that offenses for the violation of any provision
Rule.
or rule.
That rule was not exhibited.
Otherwise, on fact, my submission is that it is the article 6 from the petitioners. These are, my lord, admittedly firewood. And it is not come under expression forest produce. This is my, because we are in revisional, I am before revisional court. So this is my lord, main submission. Right?
See, that is the problem because I am in revision in this matter. So there are concurrent findings.
Divisional court has to only,
Look
there is
into
a
that.
jurisdictional error.
That is only the only jurisdictional
Therefore,
error
my humble submission is that, but there is a jurisdictional error on the fact that
that would be
the
difficult.
product seized from me, the article seized from me is not come under the expression.
It's not a
forest
log. It's basically firewood.
Fire.
But the question still remains whether that log was converted into a firewood by you inside the.
Definition of, your lordship, for a moment kindly read the book.
Hmm.
The definition of forest produce has been given. So
Eh,
firewood is not there.
No, firewood.
For the fire, what is there? Dry tree branch.
But they don't say that.
Evidence clearly says the fire.
Forest logs on bicycle. Carrying gomari and koroi logs. So these are logs. This may be converted into small pieces by you inside the forest itself, and then it was being transported. You get my point? So it's basically, Mr. Uddin, the transportation of forest produce when it is the logs or trees, it's basically cutting down of a tree in the forest.
Your lordship kindly peruse page 23 of my petition.
Hmm.
Page 23.
Can be used as firewood, but he does not know from which tree it was cut. I marked it. So that conversion may have taken place. It is not twigs and what do you call that? Fallen down some twigs, small branches you
Yes.
have collected and then brought. It's not that. The allegation is Gamari and one more. Gamari and
Koroi.
Goroi.
Koroi.
Goroi logs.
Koroi and Gamari timber on
Timber.
9 bicycle.
Ah.
Not log, timber. His evidence is timber on 9
Timber so seized. So it is the part of a trunk of a tree.
And the primary of this is that they fail to produce any document.
TP document.
Any document.
That's why the jurisdictional error that I found is your punishment is under 41.
Under 41, this is, I am coming, my lord.
Ah.
This is first part.
Oh.
The second part is the learned, both the court below, trial court as well as the appellate court, appears to be very harsh because
No, that
either or both.
Hmm. Mr. Uddin, this offense is of 2002.
Judgment is on 13.
Within 2 minutes, I can uphold this conviction, give you the probation, extend to you the probation. No problem on that. That I had on the first day itself thought about. I can do that. But when I found that the conviction is under 41,
That I have not found, my lord.
then it
Sir.
cannot be. It cannot be because until and unless a rule is framed. So I just wanted to satisfy myself because that will become a jurisdictional error.
I have made my search with all my resource, my lord, limited resource, and ultimately find this act. There is
This act is also something
something different.
different. Anyway, Mr. Uddin, you are under stay. You have that it's suspended.
It's suspended.
So don't worry. We are not sending you to jail. This court, even if
I
it
will.
finds that there is a rule, we will use our powers under the Probation of Offenders Act and we will release you.
From today, I think. After some time,
After some time, we'll see. I just want a clarification on that. Oh, Mr. Uddin, we are ready to release you on probation. There is
Fine.
no doubt about it. But I want this issue,
Well,
what it is.
Let a law be laid down.
Not the law laid down for my own satisfaction. I want to know how, because I'm getting daily at least 2 or 3 matters
Yeah.
under section 41. But same transportation.
Yes, Your Lordship.
Hmm.
I'm appealing for a respondent lordship. I don't have lordship. Instruction lordship, whether she, the present situation lordship, whether she got the.
2,000, you're paying her 2,000.
Lordship, thereafter she filed in file court, Your Lordship, divorce was granted by mutually. There is a certified copy of that.
Divorce has been granted. What is the alimony fixed?
1,20,000, Your Lordship.
That has been paid.
That instruction that I have.
Then what is left?
In 2016.
I
Your
don't have
Lordship.
any instruction lordship right now.
Your Lordship,
So, certified copy. And you have filed. She has filed.
yes, Lordship.
Unfortunately, lordship, I have no instruction.
Okay. Once a certified copy has been produced by Mr. Gogoi, how can we ignore that? And therein you have given an undertaking. Joint petition number so-and-so that they had mutually agreed on the condition that pay 1,20,000. Will not claim the maintenance allowance 2,000 which was ordered to be paid by the respondent in miscase number 133.
That was silenced in this.
And she was also, she will also not claim arrear. From the other claim, on hearing the presence so-and-so, it appears that no objection. So-and-so now when the board panel, so-and-so. Consequent to my decision, so-and-so will pay at least so-and-so incur. But Mr. Gogoi,
He go going.
T. Gogoi, learned counsel for the petitioner, at the outset has submitted that during the pendency of the present proceedings, the respondent herein had instituted title suit bracketed divorce number 21/2013 before the court of the learned district judge Lakhimpur, North Lakhimpur, for dissolution of the marriage between the petitioner herein and the respondent by a decree of divorce. The learned trial court wide judgment dated 2011-2015 was pleased to allow the said title suit by granting the decree of divorce on mutual consent on dissolution of the marriage between the petitioner and the respondent herein. Also, the said divorce was so the said decree of divorce was so passed on the condition that the petitioner herein will pay an amount of rupees 1,20,000 1,20,000 liquidiva bracket over only as permanent alimony to the petitioner within 2 months from the date of the judgment, failing which interest at the rate of 7.5% will accrue on the said amount. Mr. Gogoi has placed on record the copy of the judgment dated 2011-2015 passed by the learned District Judge Lakhimpur in title suit bracket divorce number 21/2013. So, a perusal of the same, it is found that in para 9 of the said judgment, para 9 therein, that the respondent herein had undertaken in the said proceedings not to claim the maintenance allowance of rupees 2,000 as directed to be paid to her by the subdivisional judicial magistrate bracketed S. Not Lokhimpur, comma, Lokhimpur in Miss Case number 133/2012, comma, which is under challenge in the present proceedings by the petitioner herein. Also, the said undertaking as recorded in para 9 of the judgment dated 20/12/2015 passed by the learned district judge Lokhimpur in title suit number bracketed divorce number 21/2013 being irrelevant is extracted herein below. A to A. Para 9 here, A to A. Full stop. In view of the above position, comma, this court is of the considered view that the present criminal revision petition need not be detained any further, and the same is closed in terms of the undertaking as noted by the learned trial court, learned court of district judge, comma, Lokhimpur, as noted by in the judgment dated 2011/2015 passed by the learned district judge Lokhimpur in title suit bracketed divorce number 21/2013. Any interim order here? The interim order passed by this court, wide order dated 26/9/2013, stands vacated. Full stop. With the above observations and directions, the present revision petition stands disposed of. A copy of the judgment and order dated so and so passed by the learned, a certified copy of, a copy of the judgment and order dated 2012/2015 passed by the learned district judge Lokhimpur in title suit bracketed divorce number 21/2013 is kept on record and marked as X for the purpose of identification. Oh, Miss Gugoi, upar likhibade heard Mr. T. Gugoi, learned counsel for the petitioner, as well as Miss M.S. R. Gugoi, learned counsel, appearing for the respondent. We have not put anything in your mouth.
There's a instruction is required, my lord. We have not received yet, my lord. Whether he has served out the sentence, my lord. Did not receive the instruction. And also in same 17 also, my lord.
Today I feel that people are more interested in the new cases, and that rightly should be.
Yes, my lord. Yes.
Mr. M.P. Goswami, learned counsel for the learned additional public prosecutor, submits that he be granted further 2 weeks' time to receive the instructions to complete his instructions with regard to the query raised by this court-wide order dated 16/9/2025. Prayer accepted. Registry to list this matter again on 27/10/2025.
Same prayer, my lord. I have talked to the my lord, query regarding whether he is expired or
Apple number 1.
One. 2, you have given me a certificate.
yes.
Or 2 I have given us.
What is there?
Because the PW 1, accused number 1, my lord, he is whether he expired or not. That is not sure, my lord.
Okay.
4 or 5 days they are not.
Now I understand that. Heard Mr. D.K. Bachaji, learned counsel for the appellant. Also heard Mr. M.P. Goswami, learned additional public prosecutor, appearing for the state respondent. Subpara. Mr. M.P. Goswami, learned additional public prosecutor, submits that he be granted further 2 weeks' time. 2 weeks' time to complete his instructions with regard to the query raised by this court-wide order dated 17/9/2025. Prayer accepted. Registry to list this matter again on same day, 27?
27, my lord.
Public.
Yes, Mr. Das. Anything?
There is nothing, but only actually there regarding the conducting a search, that was also not in compliance with the statutory provisions of law, my lord. But due to a minimum two witnesses are, independent witnesses are required
Hmm.
for making a search, my lord.
Hmm. PW3.
Period of 3 months. The other, the PW9, my lord, he is also independent witness, but he has not said anything, my lord, about the making search, my lord. And says, and also seizing the properties, my lord.
And this is your second offense.
Second opinion. PW3 and PW9, they are the two independent witness, my lord. What the that also.
What was the punishment given to you?
Punishment, my lord, 3 months, my lord, and also pay a fine of rupees to 2,000, my lord.
In 2009.
Most interesting, my lord, this list is prepared, but prior to that, I'm making a Malaysia search in the, my lord. On their own evidence, my lord.
Yes, anybody for the Mr. DKD? Yes, madam. What do you say?
Unavoidable circumstances.
Mr. Das, the only thing here is PW3, the evidence was considered by the trial court, also by the appellate court.
Appellate court, my lord.
And they found that the evidence to be cogent.
My lord.
And this is your second. That's the only first I would have immediately closed it.
Well,
Second, the act itself says that it should be viewed very seriously because it's double the punishment now.
well,
The trial court judgment is of 12, 13 years.
judgment dated 10/12/2012, my lord. At the trial court.
3B is for that double.
Well,
Railways Act to some.
yeah, concerned.
Were you in detention at any point of time?
Yes, my lord. That
How
my
long?
lord. Could have seen me. Bail was granted on 2/2/2009, my lord.
Arrest?
Yes, on the 22/1/2009.
And bail was granted on?
On the 3/2/2009. And but the appellate court, my lord, regular bail was granted on 14/3/2013.
You were not in detention thereafter?
No, probably, my lord. I am also not sure.
22/1 to very few days, 12 days, 13 days.
Almost 12.
Mr. Day is coming. Can the Probation of Offenders Act be applied here?
The second offense, my lord.
That also problem. Okay, we will not trouble you before the vacations. After vacations, we will send you to jail.
Well.
Had Mr. N.C. Das, Atlantic Council for the Senior Council, and Ms.
Yes, Chaudhary.
P.S. Chaudhary, learned counsel appearing for the respondent. Full stop. Heard the parties at some length, however, hearing remains inconclusive. Registry to list this matter again on 24/10/2025.
Right.
Mr. Das,
Obliged.
just see how we can,
Yeah,
just see. Because second offense is serious.
very.
So 3B, the way it is worded,
Right.
it's serious. We cannot take it lightly. But now so much years have passed. Whether we can
It can be, my lord.
provide that. Just guide.
Obliged to lordship.
Please, Lord.
Hmm.
Here in this case, the respondent, despite receiving the notice and the civil suit is going on in between the parties in the same subject matter. We approach your lordship because of the order passed by the learned session judge, because the magistrate was pleased to drop the matter as because civil suit is pending in between parties. Your lordship may be pleased to see page 40.
15/7/2013.
They are seized in the civil matter before. Perhaps they are not interested for the respondents.
What is the relief sought for in the civil suit?
Civil suit, my lord, we sought for a
Declaration. Right title.
declaration, money, the document, fraudulent documents, my lord, on the basis of which.
The possession is with whom?
But now we are in possession of the land, man.
How do I get
No
that?
disturbance is going on there. They are living amicably for since 1990.
Where do I get it? Where do I get that you are in possession now?
We are in possession, my lord, because
Where is the executive magistrate's order?
executive magistrate's order at page 40, my lord. Next at 5. Six, 7/2012.
And the complaint petition is at, starts at page. This is the title suit. Nobody had ever appeared in the matter, no?
No. They are fighting the matter in the civil court, my. Respective parties are in possession.
Title suit was filed by you
Our
or
party, my lord.
huh?
Our
Opposite party.
Yes. And she filed a written statement. It is also, I have annexed here, my lord, where she has admitted. Is mentioned in the order passed by the executive magistrate. That she has admitted.
Itu হয়ে গেল। Okay, fraudulent case. This one. You are Alauddin Laskar. Karimuddin Laskar.
Karimuddin. Party with the Alauddin.
Okay, nobody is there. We'll see. Heard Mr. M.H. Barbhi, Raj Barbhi, learned counsel for the petitioner. None has entered appearance for the respondent. Also, Mr. Barbhi has submitted that the issue involved in the present proceedings is also an issue in the title suit pending between the parties before the it's pending before the Munsif,
Munsif
Court of
Court.
Munsif number 1, Silchar. Now it is, I think, Junior Judge Civil Division. Also, as none has appeared for the respondent, this court adjourns the matter today. Also, registry to list this matter again on 17/10/2025, on which date the matter shall be taken up for disposal. Also,
Obliged.
interim order passed earlier to continue until further orders. Why? Get deep brief. 125. Who is for the respondent? Mr. S. Chauhan. You had gone for mediation. What happened after that? What is the issue? Oh, you don't have a brief in your chamber. Thereafter there is nothing. I think they have not settled the matter. Mr. Chauhan is coming. Yes, madam, what happened? Was there any settlement arrived at between the parties? Okay, we'll wait for Mr. Chauhan. Wait for Mr. Chauhan.
Yes, please, Your Lord. So, my lord, where for the petitioner, my lord, Nikki Nath. Lord, in the meantime, we have been informed that Nikki Nath has been died, my lord.
Oh.
So a report may kindly offer from the local police station, that is Jalukbari police station.
This is, you have your no children.
No,
Impotency is the issue. So what will happen to the money? Arrears. Your client,
my lord.
your client has expired.
Yes.
You make a statement.
Nikki Nath.
You make, why should I call for a report? You make a statement.
I have a certificate, my lord.
No, if you make a statement that she is no longer want to close this matter, we'll close it.
Yes, yes, ma'am.
Huh? Is it permissible? Don't press it. What can I do? Mr. N. Ahmed, learned counsel for the petitioner, on instruction submit that the petitioner during the pendency of the present proceedings had passed away on, had expired on
27, 2018, my lord.
20.
27, 1, 2018.
20.
21,
21,
27, 1,
07, 21?
2018.
July, August,
Yes.
what?
On On 27 January 2018.
27 January 2018. Accordingly, he submits that the present criminal revision has been abated and accordingly would not like abated. Full stop. In view of the above submissions of the learned counsel for the petitioner, comma, this court, the present petition, the petitioner having expired during the pendency of the present proceeding, the present revision stands abated. Full stop. Accordingly, the criminal revision petition stands closed.
Must be.
Ah,
20, my lord.
20, what happened?
My lord, they united, my lord, living happily, my lord. Today morning, I confirm, my lord, telephonically. So, my lord, there is no, my lord, challenge the order of maintenance.
What happened? You are not pressing that.
No, my lord, I am for the respondent.
That's what I said. That amount.
Living together now.
Okay. Heard Mr.
SS Ahmed.
S.S. Ahmed, learned counsel for the petitioner. Also heard Mr. S. Chavan, learned counsel for the respondent. Mr. Chavan, on instruction, submit that after the institution of the present proceedings, comma, there was a reconciliation between the petitioner and the respondent, and they are both now cohabiting as husband and wife again. Also, in view of the above position, comma, Mr. Chavan submits that the respondent would not be claiming the maintenance as awarded by the court of the judicial magistrate first class Huzai. Also, in view of the above submissions of Mr. S. Chavan, learned counsel for the respondent, this court is of the considered view that the matter need not be detained any further and can be closed in view of the reconciliation occasioning between the petitioner and the respondent herein, and also the undertaking of the respondent that she would not be claiming the maintenance amount as awarded by the judicial magistrate first class Huzai in MR in case number in an MR number 279/2011 white judgment dated 19/10/2013. So in view of the above, the present criminal petition stands closed. Revision petition stands closed.
My lord, on the last question, was directed to obtain some instruction regarding my lord list. And I received a verbal instruction that my lord earlier it was part wise. The list was part wise, 2, 3 different.
Okay.
And after that it was consolidated.
Mr. Where is that material?
Material, my lord, for that, my lord, I have applied for.
Mr. J.M.A. Chaudhary submits that in terms of the query raised by this court by the order dated 3/9/2025, comma, he has received instructions in the manner which would go to be received instructions in the manner. Also, he submits that an explanation is available with regard to the placement of the petitioner herein at serial number 3489 in the voters list of 2023-24. When explanation is available as to why the petitioner's name was placed at serial number 3489 in the voters list of 23-2024 when she was placed at serial number 272 earlier. About 272 in the voters list for the year, voters list of the society for the year 2018. He submits that he be granted a 2 weeks time to file his affidavit in the matter. For prayer accepted, registry to list this matter after 2 weeks. For the matter be not treated as tied up and or parted with this court with this bench any further. Entire colleague
Or it's okay, but I presume the interim or I cannot check. I'm so sorry whether it's time bound or not. Item number 23. If it's time bound, then it needs to be.
5 days before interim order is there.
Interim orders passed in the above noted writ petitions shall stand extended till the, shall continue till the next date of listing.
Obliged. Wait.
None appears for the parties on call. Also, register to list this matter again after 2 weeks. Also, the matter will not be treated as parted and or tied up matter with this court any further. $25 to ito no ini. $25 to. Ito 27 hobo. Oh, ito nalagay ito likiban. Yes, we had required the notice to be issued through the jurisdictional police station. Petitioner, 26, 25. Okay, seen the office note dated 22/9/2025. Notice issued through the officer in charge, Musalpur Police Station, Baska, in terms of the direction passed by this court, wide order dated 10/9/2025, requiring the presence of the petitioner before this court. A service report of the notice, service report of the notice issued to the petitioner through the officer in charge, is awaited. So accordingly, registry to list this matter again on 27/10/2025. A fresh notice in the matter be issued to the petitioner through the jurisdictional police station, requiring his presence before this court on 27/10/2025. None appears for the petitioner on call. Mr. Nandi, D. Nandi, Learned Counsel, for the respondent number 10 to 15 is present. In view of the above, the registry to list this matter after 2 weeks on a date to be fixed by it. The matter be not treated, treated as a parted and not tied up matter with this court any further. Yes, Mr. Gogoi. No.
This matter, my lords, perhaps lordship has raised a query regarding section 41. My lord, that matter is coming, second connected matter is coming tomorrow. My lord, it's coming as item number 1 tomorrow. That either that punishment that we have framed rules under that regulation number 41. My lord, we are also examining
40.
it.
Because without that 41 cannot be.
Yes. 40, rule 41. So far, till now, my lord, we have not found anything. Till now. But there is
Then how is your officers
no, my
filing offense report under 41?
But there is a corollary, my lord, because we control the wood-based industries. So it controls the what has come out from the till now, that every forest produce need not come from forest. Whatever is inside forest, you cannot touch it. But whatever comes out, but everything, my lord, but 41 should be there. So we have asked for some additional.
That is not the
documents,
answer.
That is why, my lord, it's only tentative. We have called.
I
for
want
some
a written
documents and
instruction from your competent authority on that.
Yes, they are also examining it. A rule, we have not found any rule. Maybe there are some executive instructions that may also help us.
But kali ebo paribo ne tu. Kali.
Maybe just listed because my lord, if
Mr. D. Gugoi, Learned Counsel for the Learned Standing Counsel Forest Department, who was requested to receive instructions in the matter, submits that similar matter is listed tomorrow. Accordingly, prays that the present matter be also taken up tomorrow. That is kali date 20 ki man hobo?
25.
Accordingly, registered to list this matter again tomorrow, 25/7 to 25/9/2025. Itu ki itu tu. Service na itu kan.
Along with tomorrow's item number 1,
Registered to list this matter again on 14/10/2025 for delivery of orders. The order delivery of orders is deferred today. Order delivery of orders is deferred today. Registered to list this matter again on 14/10/2025. Duta yake kori diya. Same order duta. Yes.
Item number 2, my lord.
Huh. We'll pass the order. Actually, what had happened was the file did not reach me yesterday. So I just have lost touch. We'll just go through it. We'll give a date. We'll pass that similar order. Don't worry. But I just want to satisfy myself. on
Yes,
that.
sir.
Okay.
obliged.
Okay, same order video.
14th Lord.
14. On that day, let's see. 14, we'll pass the order. Google. Thank you. Aizo, baki kini kam. Yes, Mr.
It could be taken up after vacations, my lord.
Was thinking election day, vacation.
That is what I'm hearing from the morning. I am taking up the old 2013, 12-13 criminal appeals and revision. So today it was very reluctant. And I also thought, nah. Hey, it order, eh? Last when? But this time we will proceed next time.
He has to move the matter because.
When?
October 29th.
Any date? You give me a date.
28, 29.
29? Done? 29? 29. Yete khali? Same order. Khali date to tomorrow 29 hobo. 29/10/2025. Thank you.
Deeply.
Deeply obliged.
Happy vacations.
Thank you, same to you.